Okay, we might kick off. Well, thanks everyone for joining this month's webinar. Today we'll be talking about IP and trademark essentials for small businesses. I'm Alex Sola. I'm the co-founder of Sprintlaw. For those who are not already clients of ours, a quick introduction to who we are. We're an online law firm really designed for small businesses and startups. We have a team of lawyers who work across all the different areas of law, from things like IP, which we'll be talking about today, all the way through to contracts, e-commerce, privacy, employment, getting your business set up, finance, consumer law, and pretty much anything else your business might need. The way our model works a bit different to traditional lawyers that charge by the hour. We're completely fixed fee. We give you a quote for your services, and that's kind of how much it costs. And for those that want to build ongoing relationships with our team, we have an optional but fairly popular membership service where you can book free consultations and access a range of other benefits and things. A little bit more about us. We have been around for about 7 years now. We have a bit over 6,000 clients, lots of positive Google reviews, and we're very much all about sort of turning the bad reputation that lawyers have on its head and providing really high quality customer experience. We've got a team of 50 staff, won lots of industry awards, and Australia is mainly where we're based, but we, as of recently, have offices in the UK and New Zealand. So through to the content of today's presentation, we're going to be talking about intellectual property and trademark essentials. Trademarks in particular, and intellectual property is one of the sort of areas where we get the most requests. And I'd say trademark is actually the area of law for smaller businesses that we see the biggest sort of number and volume of issues. It's something people don't know much about, may think that they have sorted. And ultimately, we see a lot of businesses face a lot of legal trouble because they haven't got their trademark and brand supported. So it is definitely a good webinar for you to come along to. And it's a kind of personal mission of mine to spread the word about these issues. So we'll be beginning by talking about sort of different types of intellectual property. How can you protect your brand name, and other creative ideas that might be core to your business? We'll then dive into trademarks specifically, talk about what they are, how the process works, what happens if someone's using your brand name, what can you do? We'll then talk about copyright. What is it? What protection does it offer your business? And finally, we'll talk about confidential information, which is not really a form of IP, but something that's quite important in terms of protecting these same kinds of sort of intellectual concepts in your business. I like to take questions along the way while we're talking about a topic. So if people want to ask any questions about anything I'm talking about, please do feel free to drop it in the Q&A, and I'll try and get to them, provided we don't get to too many, as and when you ask them. So let's begin with a sort of bit of an overview to intellectual property. What is intellectual property? Well, it actually refers to the sort of intangible assets of your business or, of an individual, which, are different, of course, to physical assets like, cars and homes and things like that, but are nonetheless treated by law as assets. And so the sort of 5 key types, and these aren't all the types, but the 5 key types of intellectual property you hear about and that may be relevant to your businesses are the ones on screens now. We have trademarks. These are things that are used to protect your brand, logos, phrases, shapes, other things like that represent your brand. We have copyright. These protect original ideas that are recorded in material form. These are things like, artworks, literary works in a business context. Maybe they're software or business procedures and documents, as well as recordings and film productions and things like that. Confidential information is about protecting confidential ideas or concepts that you might share with people, business strategies, business plans, those sorts of things. Designs are there to protect sort of product designs, things like furniture designs or other kinds of, product designs that are original and unique. And finally, we have patents. These are really for inventions, new pharmaceutical products, robotics, things that are scientific in nature and are seen to sort of push forward sort of human scientific progress. So these are the different types of intellectual property. Now, because we only have limited time in the presentation today, I'll be focusing on trademarks, copyright, confidential information. If you are, I'll just quickly address the other two. If you are interested in learning more about designs, of course, do feel free to reach out to our team. We do help with that stuff. It's mostly relevant for people that are in sort of product design businesses and, again, want to protect a a shape or a blueprint of one of their products. So it is something that we can help with. And then patents, there are really specialist sort of patent attorneys out there that can help with those things. People think that a lot of things are patentable, but actually not that much is patentable. It is very much for things like the COVID vaccine or some new scientific breakthrough. It doesn't apply to things like, a new app or a software unless there's something very, very scientific about it. So it's not really that relevant to a lot of smaller businesses. But again, if you think you may have something patentable, you're welcome to reach out to our team and we can connect you with a patent attorney. But for today's presentation, we'll definitely just be focusing on these first three: trademarks, copyright, and confidential information. So let's begin with trademarks. What are trademarks? Well, trademarks are the registration that you can get to protect your business's name, its logo, and catchphrase and other sorts of things. If there are shapes that are used to identify your brand, you can protect those too. So for example, for Coke, it's things like the Coke bottle. And in some cases, colors. So, if you are in an industry where you're using a non-traditional color to help represent your brand, Tiffany blue is an example, the Barbie pig's another example. These things are also potentially registrable. But again, the business name and the logo and potentially the catchphrase, those are probably the most common things that businesses are looking to protect. So just to explain in a bit more detail about how trademarks work, they're available by a registration system. So now, there is something called unregistered trademarks, which I'll touch on kind of at the end of this section. But in most cases, to get a trademark, you need to actually go register it. You need to pay money. You need to, in Australia, go to IP Australia, fill out the form, go through the process, or get a lawyer to help you with that. Get it registered. It's different to other forms of intellectual property in that way. If you haven't done the work of registering it, then you don't have a sort of clear right to your trademark. Now, one thing I'd like to point out here is a lot of people think that they have registered their, let's say, business name or brand name, because in Australia, when you set up a company or a sole trader, there's something called a business name registration, and you'll pick a name and no one else can be using it. And you think, yes, I've sort of secured my name. It's my name. That registration, it does not give you a trademark. It does not give you exclusive rights over that name that you may be using. It's just the kind of administrative requirement for you to, under the Corporations Act, have, a name that, is registered, which you're using to communicate your business to the public. But it doesn't give you kind of brand rights. To explain what the difference is in a bit more detail, or explain why it works that way, we're called Sprintlaw. We have the business name registered for Sprintlaw. But if we didn't have a trademark for Sprintlaw, maybe another law firm called something completely different, they might introduce a division called Sprintlaw, and they might want to protect that brand. They may register a trademark. Even though I've got the registered business name for Sprintlaw, if there's some company with a division called Sprintlaw with trademark, it could have posed an issue for our business. So trademarks are not just about the business name registration. And this is where I think there is this big misinterpretation with smaller businesses. We see they think they own their name and they actually don't, and they run into issues. So it's a separate registration. It costs money. It's with IP Australia. If you're not sure if you've done it, chances are you probably haven't. So just wanted to make that clear. So once you register your trademark, it gives you the right to exclusively use that trademark. People can't use a trademark that use your phrase or a logo that is deceptively similar to yours, or your business name in relation to similar goods and services. So just on the next bullet, to clarify that a bit further, when you register a trademark, you register it in relation to particular classes, which are kind of like industries, and in particular countries. So again, to use the example of Sprintlaw, and we have a screenshot of our registration in a couple of slides' time, so I could show it in a bit more detail. But again, to use the example of Sprintlaw, we have the trademark for the word Sprintlaw and our S-shaped logo. And we have registered them in class 45, which is in the legal industry. And we've registered it in Australia, in the UK, in New Zealand, Canada, and a couple of other countries around the world. So what that means is, in the countries that we're registered, in the industry that we're registered in, which is legal, no one else can use Sprintlaw in relation to similar goods and services. So no other legal or legal related business can use Sprintlaw. They probably can't use Sprint Legal or Sprint Lawyer. That would probably be considered to be deceptively similar. We have the exclusive rights to our brand in our industry. Someone could start a restaurant called Sprintlaw that serves really fast coleslaw and get a registration in the restaurant sort of class, and that might be fine. Fine from a trademark perspective, but probably not from a business name perspective. But it is very much about industry. So that's kind of how it works. If you're in law and you're thinking of using Sprint Lawyer or Sprint Legal, because we have the trademark in our countries, it's a barrier to that. And so you can apply that logic to your business and your business name and have a think about what industry you're in. There is a list of classes or industries, and lawyers can help you pick out the correct one or maybe multiple for your business if it applies to multiple. And that's kind of part of the registration process. Now, once you register, the registration lasts for 10 years and can be renewed indefinitely. And oftentimes businesses will just continue to renew it and have a continuity. You don't have to battle it out again every 10 years. Once you have it, it's something that you can just renew. It can be licensed to others for use. It can be transferred, for example, if your business is sold. And it's really the main way to get ownership of over your branding. And what I say to a lot of businesses is, you're spending time, money, effort in setting up your business, building your brand name, building your brand equity. You want to make sure that you actually own it. And you don't want to find out because you never checked or you didn't really know how to check that in 3-4 years' time, someone else is out there using the same name as you, and either issues you a cease and desist or force you to rebrand, and you lose all the goodwill that you've got in your business. And this is something that we see, I think, too many times happen to smaller businesses. So in the case of Sprintlaw, being lawyers, we often do legal things in the correct order. So when we first set up the business, first thing we did was register the company and then get the trademark. It was at the top of our kind of to-do list. Again, something I recommend to most businesses, float this one to the top of your to-do list as in terms of your legal requirements. In terms of working out if you need a trademark, and what you should be trademarking. Of course, your business name is often the thing you want to trademark. Your logo is often a thing you want to trademark. If you're a product business, maybe you produce a range of different products, or maybe we have a client that is in the wine industry and has a bunch of different wine products. Maybe there are more things than your business name you might want to trademark. You can actually trademark your individual product names. Work out, what is your brand? Is it just your business name? Is there more to it? Is there a key phrase that you use that's unique? For us, it's business legals made simple. Maybe you have something like that. Is there a logo? What is the brand? And then do you actually own it? So go and check, have you actually registered trademarks for this? Is it yours? And then, once you've secured that ownership, understanding, well, now that I own it, how do I use it and how do I enforce it? And we'll go through some of these in a little more detail. Brendan's just asked a question, how do you know if your trademark is not already taken? Look, there's a trademark search tool on IP Australia's website where you can do a little bit of a search for, your business name or your product name, or it's a bit more difficult with logos because they've got a text search tool for logos. It can be difficult to find out if there's a logo like yours on there, but there are ways to search for it. So you can have a look at yourself. Of course, looking yourself, but not being a legal expert may not give you a definitive answer because, like I said, there's this like similarity test. So even if there's not an exact match on IP Australia's website, if there's something that's a bit like yours, then you may want to get some legal advice as to whether it's taken or not. The best way to find out if it's taken or not is to actually begin the application process, which we'll talk about in a moment. And IP Australia, as part of reviewing your application, makes an assessment, looks at the register, and will tell you whether they think that there's anything else that's too close to yours. And discussions can ensue if that happens. But yeah, the short answer is IP Australia has this search tool, so that's the place to start. Andrew's also asked the question, as a new SaaS company, customers and investors often ask what IP we have. The more we look at it and drill down into their concerns, they're usually asking if someone can easily replicate. Anyone can replicate a platform, so it's a hard question to answer. IP seems to be a catch-all, but not easily protected for SaaS business. So, Andrew, great question. I might address that when we get down to copyright. There are some things you can do for a SaaS business to protect your intellectual property, but for the section I'm talking about now, of course, you want to protect your brand name, your product name for your SaaS product. That's really important. If you're ever acquired in the future, then people will be wanting to know that you own the name. So trademark's relevant there. In terms of your code, we'll talk about that in the copyright section. Jody's asked, is there a calculation to work out the value of an existing trademark purchased with a business? There isn't like a formula where you would say a trademark is worth X dollars. It depends as part of the goodwill and brand value. The brand value may be higher if you have secured the brand name. If you don't own the trademark for your brand, when you're selling it, it may knock off the purchase price, but the price of a business sale is usually somewhat subjective for a private business. You can have people look at your revenue, your costs, and do a valuation, but it's often a price just negotiated between the buyer and seller. And whether or not you own a trademark and how big your brand is a factor in that, but not sort of scientific in a formula sense. And Rhonda said, is the first application usually the most successful? It doesn't quite work that way with trademarks. I'll run through the application process in a slide's time, and hopefully we'll address that one. Let's talk about ownership. How can making an application? How can you make an application for a trademark registration? Sorry for the typo there. In Australia, it actually takes 7.5 months to fully secure your trademark. So it's not an instant process. It's not like it's 3 days and it's done. As we'll see in a moment, you get a bit of an indication pretty quickly if you use a particular process with IP Australia, and so you're not left biting your fingernails for the whole 7.5 month time, but it really does take that long to get it fully secured. And what's happening when you're making an application is, okay, is there anything deceptively similar on the register? Is your trademark distinct? And again, the Head Start process, which is the process I just mentioned, can really speed up the at least the knowledge as to whether your trademark's going to come through. But in terms of who's assessing that, IP Australia has a team of assessors. They're people that look at every application that comes through and will review it. And they're considering these kinds of questions. Is this distinct enough for the industry? They have a look at the register. Is there anything like it on the register? And if they're satisfied that what you've applied for is unique, then they can kind of let you through to the next stage. If not, they may reject your application or have some questions about your application. So to your question, Rhonda, it's not necessarily about whether it's your first, second, or third application. It's really more about these two questions. Whether it's your first or fifth application, are you getting through on these two sort of points, similarity and distinctiveness? Then how does the international aspect work is something we get a lot. Yeah, when you register, you're only registering in Australia if you use IP Australia. There's something called the Madrid Protocol, which is an international treaty that Australia has with many other countries internationally. There's a service through the World Intellectual Property Organization, WIPO, where you can actually upgrade your Australian registration fairly easily to registrations in a number of other countries around the world. I think there's 130 countries on there. So doesn't mean you'll get it in all the countries. They have their own registers, their own rules. But the Madrid upgrade, as I like to call it, they don't call it that, but it's a good way to think about it, can be done within 5 months of your Australian application. You can kind of upgrade it to, on the same grounds, apply in a bunch of different countries. Otherwise, you're also able to just directly file with lawyers in other countries. Again, for the example of Sprintlaw, we registered in Australia and we used Madrid for, I think, New Zealand and a bunch of countries around Europe. And then later on, we did our US and Canada trademarks when we decided we might expand there on a direct basis. So you can either use the direct basis or Madrid. It just depends on how ready you are to outlay the funds, the additional costs, if that makes sense. Rondas, is the Madrid application cheaper than doing individually? It's a difficult question to answer because it depends how many countries, the Madrid pricing for each country, and what kind of lawyer you can find in each country. I think typically if you're going to do probably more than 3, it's going to be cheaper in Madrid. If you're just doing 3 or 2, it can be around the same price. One of the advantages, of course, with Madrid is you don't have to deal with 5 direct law firms and the challenges that may come with that. So I'd say the more you do, the more likely it is to be cheaper through Madrid. But yeah, you may just want to get multiple quotes depending on what countries you're doing to confirm that for your business. So let's talk about the typical trademark registration process. And this head start thing that I mentioned, there's actually different ways to register a trademark. You can go through a traditional application process, and for larger businesses, it's often done not through this head start process. You get a little more control over the description and details of your application. I'll explain what that means in a couple of slides' time. But for the majority of our small business clients, we just use this head start approach because it's simple, easy, cheap, and a lot quicker. And you find out very quickly, at least a sense as to whether you're going to get through or not. So step 1, you submit an application with IP Australia, explaining what your trademark is, what industry you want to protect it in, and a little bit of details about your protection. Pretty quickly, within usually a week, you get a report back from IP Australia, and they will let you know on a preliminary basis whether they are going to approve your application. They do basically a quick check and tell you whether they think it'll go through or there's likely to be issues. So you do find out fairly quickly your prospects of success, which is why I said you don't have to bite your fingernails for 7.5 months. At that time, they may say, look, your application looks okay, but this particular part of your trademark or the way you're describing it, it's a bit too broad, et cetera, et cetera. So they might ask some questions which you can easily fix, or they might say there's a very low probability we'll approve this. It's not distinct enough, it's too generic, or someone else has something on the register that looks very, very similar to it, and we're likely to reject it. Once you receive that report, you can either let the process lapse. Maybe you decide after hearing back from them you're going to change your brand name. Or if you want to tweak your application and reduce, what you're actually applying for, you get a chance to amend it within a couple of days, and you don't pay an additional fee for an amendment if you do it quite quickly. After that, you can formalize your application. You wait about a month, and you get the formal report, which is usually consistent with that interim report, although sometimes you get unlucky and IP Australia has a more detailed look and they say, we didn't pick this up the first time, but actually we're going to reject it for some other reason. But hopefully you get through that formal report process. Then you have about 4 months until, a 4-month period where, 4 to 6 month period where after you've got your formal report, you can be subject to potential oppositions from other trademark holders. So IP Australia are the kind of first gate to getting your trademark, but other people that already have trademarks also have the right to say, hey, I don't want this new trademark coming in, because while IP Australia, you may think it's okay, we're actually worried that this might dilute our brand. And the way that works is, again, to use the example of Sprintlaw, we get a digest from IP Australia telling us about new registrations that are sort of in the halo of our registration in the legal industry, and we monitor them. And if we saw someone make an application for, let's say, Sprintlaw, and IP Australia had decided that that was fine, it wasn't similar enough to Sprintlaw, and they'd let it through, we may be able to file a notice to oppose and say, look, we're not happy with this. We think Sprintlaw is going to confuse consumers and trade off our brand equity. We're not happy with this, and we can oppose it. And if we put forth an opposition, it can block the process for the person trying to file a trademark, and they have to then respond to the notice to oppose. An argument may ensue, and either the parties will work it out between themselves, or IP Australia may make a determination, or it can sometimes even end up in a court decision. So Again, if you're lucky, your process just goes all the way through with no oppositions and a formal approval. But we do see, not infrequently, there be issues in this opposition period where particularly larger companies that have trademark teams are quite protective of their trademark, more so than IP Australia's reviewers, and will file oppositions and force people to either rebrand or change their branding. So as you can see, this process typically takes 7.5 months, but the oppositions can drag it on. It can go on up to a year. And so, again, we always advise people to get started as soon as possible. And if you have something distinct enough, hopefully you can kind of get through without too many headaches. But it's important to be aware that there are at least a couple of places along the way where issues can arise. So this is a bit of a screenshot of our trademark registrations, just to give you a sense of what they look and feel like. So we've got two on this slide. We've got Sprintlaw, the word trademark. You can see kind word, and then Sprintlaw. The owner is our head company, which holds all of our intellectual property. For businesses that have multiple entities, that's quite typical. If you just have one company, that may be the owner, or if you're just a sole trader, it may just be your personal name that shows up here. We filed in 2017. When we were in class 45, which is the legal class that I mentioned, and you also write a description of your trademark, which even within the class is further narrowing. So you can see, legal services, legal information services, providing information. These are the various sub areas of law, quite broad, in which we have the right to Sprintlaw. So this very broad application is not done using Head Start. The Head Start process, a limitation of it is that the description's a little bit more kind of automated. It's from a pick list. So you don't get as robust a protection as you will if a lawyer drafts it for you. But for most small businesses, the pick list is pretty comprehensive, and there's not all that much value to be gained by this lengthy protection. But of course, if brand is really, really core to what you do, you may want just that extra level of detail that we've done here. And then we also have a registration for this logo, and you can see kind figurative, so it's a kind of logo mark. It's again class 45, and it's protected in a lot of the same areas as our mark. And we only filed this in 2020 because our original Sprintlaw logo was different. So these are an example of some registrations, and if you're successful in getting your application through, you will have your own pages on IP Australia's website for these kinds of trademarks. Rhonda's just left a note that the opposition's gone on for 2 years. So you can see that this process really can extend if there are issues in this opposition period, and become quite an issue. Big question. I've just been saying it takes 7.5 months to register your trademark, and you're maybe thinking, well, I don't have one, and I'm already using it. So when can I actually start using my trademark? Look, it's very common for businesses to begin using their trademark as soon as they come up with the name to start commercializing it, and prior to getting the full registration. It's of course risky to do that in case someone does decide to sue you for breach of their trademark. I would at least advise businesses, while maybe not necessarily waiting for the 7.5 months, to just sense check that there's not some obvious infringement that's going on, that they're not obviously copying someone else's trademark, or there's someone that's not obviously going to be mad by and likely to send a cease and desist letter by virtue of you using your business and brand name. Then it's a risk decision for you as to whether you want to wait or just start trading. But the majority of businesses do start trading straight away, and would only cease if they have an issue in the trademark process. That's kind of a view on that one. If you want to be very risk averse, you should wait until you have your trademark registered. But in practice, that may not be practical. So just be aware that there's a little bit of a risk, and at least do a sense check is my advice on that one. Next question, what's the difference between that little TM and that little R logo people have seen? The R logo you can only use once you have a registered trademark in Australia with IP Australia. It's actually, you can be fined, or there's, I think, fraud actions that can be taken against you if you're using the R logo without having registered it. So that's reserved for getting through that application process. If you're not yet through it, but you want to just make it clear that you're kind of going through that process, you can use the TM logo without having a registered trademark yet. And you can use it if you have a registered trademark. It's a more unregulated sort of usage. It's commonly used for these things called unregistered trademarks, which again, I'll touch on in a moment, but are a kind of backup area if you haven't yet registered your trademark. So what happens if you've got your trademark and someone's actually infringing it or copying it? Well, the most common first action is that they get sent a cease and desist letter, which can be sent by you or by a law firm. And it basically says, you must cease using my trademark. Here is my registration. Here's my registration number. If you don't cease, further action will be taken. Sometimes you can be more aggressive and say, I demand compensation because you've been taking my clients, confusing my clients, or diluting my brand, and I've suffered XYZ loss. Not only must you cease use, I also want some compensation. In our experience, particularly when the cease and desist is done against a small business, that actually is quite a strong deterrent, and a lot of people will stop. But it can lead to debates and legal action that proceeds. If the matter proceeds, you can then end up suing them, or seeking an account of profits. So getting actually a right to any money they've made off your trademark by trading off your trademark. So there are sort of pretty strong legal rights that you have as someone that's owning a trademark. Of course, with all the legal action comes legal cost and distraction. So a lot of people just are really going to be focused on the cease use aspect to protect the mark and make sure they're the ones that are getting the benefit of the brand building. So that gives you a bit of a sense of what you can do to enforce your trademark. Now, just moving into the second area of intellectual property, copyright. So copyright is intended as a legal mechanism to protect creative original works that are expressed in material form. That sort of legal jargon really has two elements to it. The first is this element of originality, so something that's original. There's not a strong legal definition of originality, but there are many sort of cases that sort of describe what it is. You've come up with it. There's an element of novelty, etc. And then this second aspect, which is expressed in material form. So there needs to be some material record of the thing you created. It's often said there's no copyright in ideas. If you come up with an original idea, oh, I've just thought of something great, that's not copyright yet. If you record that idea in the form of a book that you've written down either digitally or on paper, or an artwork that you've actually created, or in some other material mechanism, the moment it's expressed in material form would be the moment that original concept actually gains copyright protection. So this material form element is quite important to copyright. This is taken actually from the Copyright Act, and is a list of types of works that are protectable by copyright. There's these kind of broad, what they call Section 3 categories: artistic works, literary works, musical works, and dramatic works. Paintings, sculptures, graphics, etc. you can see is what's considered artistic. Literary is one that's quite relevant for business. So it protects things like books, textbooks, articles, and maybe blog posts that you might do. And particularly for software companies, I've bolded computer software. So software code itself can be copyright if it's original, and it's considered a literary work under the sort of the Copyright Act. Also, designs, the interface of computer programs or websites or applications, they may be considered artistic works for copyright purposes. So, columns 1 and 2 are often quite relevant for software businesses. For non-software businesses, your strategy documents, your processes, your training materials, things like this presentation, provided that they're original and recorded in material form, are all potential candidates for meeting this test of copyright protection. So this is not just about art, and there's a lot of sort of non-art business applications of copyright, which is sort of why we're talking about it. Then we've got musical works and dramatic works, are other two kind of areas of copyright protection. So in addition to these things, there's also what the Copyright Act calls other subject matter. and these are more sort of embodiments of these artistic, literary, musical, and dramatic works, which themselves have a separate copyright protection. So things like films, digital recordings, online films and videos, music videos, broadcasts, and the layout and looks of a publication have actually a separate copyright protection. So to give you an example, the Beatles, wrote this song. People probably know "Let It Be," and there's a recording of that in one of their 1960s albums. So the writers of the song, I think Paul McCartney was the writer of that song, will have a musical work copyright of the song, and anytime that song is played in any form, that's a potential use of the musical work copyright. And then separately, the producer of the 1960 recording, that particular sound recording, they also have a copyright because they've created that instance of the song. And so if that's sampled, copy and pasted, that particular recording, there's a second copyright at play, which is the recording copyright. But the producer has no rights to, if someone does a cover version, that's only about that first copyright. So that helps you understand the difference between this other subject matter and works. One is about the particular manifestation of that copyright, and the other is about the underlying work in whatever form that it's used. So this is a broader protection. So that's the kind of universe of stuff that we're talking about in the case of copyright. Now, how do you protect copyright? And hopefully here we can start to touch on the question Andrew asked earlier that's relevant to software companies. We've already talked about brand protection, but how do we actually protect this copyright, these literary works in our business? Well, in the case of copyright, it's not like trademarks where you need to go register it. Ownership arises automatically upon creation. So the author of a copyright work, the second it's original and recorded in that material form, whoever made it owns it. And of course, you may be thinking in business as well, I've got software developers writing my code, then some of them are contractors, some of them are employees, some of them are outsourced. I have employees who are involved in making my presentations or my documents. Is it all owned by them? Well, technically, the second they create it, yes, they are the owners. The individual person that created it owns it. Now, how do you as a business ensure that you own it? You have the rights around the copyright, and we'll come to what those are in a second, and it's your property. Well, copyright can be transferred or licensed. And the most common way we see this happen is via employment agreements, IP assignment deeds, IP license agreements, or otherwise. So, it's very typical, and people would have seen this in employment agreements, for there to be a clause in an employment contract that says, I, the employee, hereby agree by becoming an employee of this company to transfer all intellectual property that I create in the course of my employment immediately upon creation to the company. And what that phrase means is, that the second the employee actually creates the sort of copyright, it will be actually transferred to the PTY Ltd business sort of entity. So if you're a business that's relying on employees or contractors to actually create intellectual property for you, and in the case of a SaaS company, you typically have a team of developers, UX designers, and so on who will be creating your software application. Not only do you want to make sure the name's protected, but you actually want a record of, here's all the people that worked on my software project, and here are the contracts that show that they've assigned all of the intellectual property they've created over to my entity. And if you have those two things, the brand protection and then a folder of contracts and a bit of a record of who did what, that's actually how you establish ownership of copyright. It's not a registration system. There's not a place that you go and say, I've registered my software for copyright protection. Instead, it's actually a series of agreements that record your transfer of ownership from the creator to your business. So very important to check those IP clauses in your employment agreements, your contractor agreements. And if you don't have them sorted, you can use these documents called IP assignment deeds that can actually have retroactive effect. And we do a lot of these to clean up people's copyright ownership, and you'll get people to sign over copyright back to your business. So hopefully that answers Andrew's question. So what happens when you get copyright? Well, once you have copyright ownership, you have the exclusive right to reproduce that work, to publish that work, and to communicate it to the public. So no one else can take your software, your literary work, your presentation, your strategy document, whatever it is that you've created. They can't copy it, or at least copy a substantial part of it. Some law around what copying actually is. It's not taking 2 or 3 words. It has to be what's called a substantial part. Taken a substantial part of your work and reproduced it, published it, or otherwise communicated it. If they do so, generally they will be infringing your copyright, and you have the right, again, sort of like trademarks, to issue cease and desist and sue them for damages or account of profits. So again, it gives you this ownership right and this right to stop others from using it. And that right, trademarks only last for 10 years, have to be renewed. The copyright ownership lasts for 70 years after the death of the author, or if we don't know who the author was, it's 70 years from when it was created. So it's a very long-term automatic protection for this kind of IP, which is why it's quite important, really, to make sure that it's yours, because you get 70 years if you own it, if that makes sense. So just to zoom in, what are the key assets that have copyright in them? These are things like software code, graphic designs, photos and videos, business templates and collateral, ad copy, manuals, illustrations, internal branding strategy documents. All these things, provided that they're original and we have some material record of them, these are the things. If your business has anything on this list, or stuff on this list, that is important to your business, that you don't want competitors copying, that you don't want other people using, copyright is the mechanism for protecting all of this kind of stuff. And again, you're doing this through your agreements. So as I said, who owns it? The author owns it unless contractually agreed. It's owned by the author who created it, which is why you need to make sure you got these documents that transfer copyright ownership over to you. I mentioned already, this is typically done through the employment or contractor agreement, a clause in there that covers intellectual property ownership. So you want to make sure that that clause is watertight. Template employment agreements are usually pretty good. They usually have a pretty good IP clause, although I have seen some online templates that are missing IP clauses that are kind of being spread around in Australia. So you should double check your employment agreements. But contractor agreements are actually where I see things fall down, where businesses are engaging a contractor. They just sign whatever the contractor gives them, or they actually have no contract with the contractor. If there's nothing in writing that explicitly covers IP, your contractor actually still owns the stuff that they made for you, if it's original. And that's an issue. And that's something that often comes. I used to work in sort of technology M&A, and we would, I worked for a large law firm. We represented a lot of large companies that would be acquiring smaller businesses. And the number one issue we'd see when we were buying a software company is that, a bunch of random software developers had worked on this application, and there was no record to say that the company actually owned the work that they'd done. And this just didn't necessarily mean that those software developers were out there going to sue the company. They probably didn't know either, but it did mean that there was risk for the buyer, and ultimately at the time of sale of the company, the value of the business goes down by some large percentage because the IP is not secure. And again, coming back to Andrew's questions, that's why if you've got a nice library of contractor agreements that have been properly done, you avoid those risks that can actually go straight to the value of your business, and you can answer the question as to how you own your IP. Rhonda's also asked the question, how does that apply to, say, using business cards and advertising by Vistaprint? Do Vistaprint own the copyright, and are we leasing it? Yeah, good question. I'd have to look at, obviously, Vistaprint's specific terms to tell you exactly how they work. But in general terms, these online sites where, they have a series of designs and ways of presenting things, and you pick from a template and then they print it for you. Typically, unless you're paying a lot of money, they're not going to let you exclusively own that design or that kind of it's probably artistic work. It would be considered from a copyright perspective. They're going to give you what's called a license to use it. So yeah, you, as you said, sort of described it, Rhonda, sort of like leasing it, and we've got this here IP license agreement. So they'll let you use it, but when they grant a license, there's different kinds of license. Probably they give you what's called a non-exclusive license. So they'll say, Rhonda, you by paying us, we're going to give you X number of business cards, and your business will have a non-exclusive license to use these business cards just for the purpose of promoting your business. It'll probably say as well, it's a limited license. You can't on-sell these to other people. You can't use it for 3 other businesses. You can only use it for your business, et cetera, et cetera. And that'd be part of their business model because obviously they want to reuse the same designs for a number of different businesses. So they would be the owners, but you would have a license to use it, which means you're not infringing their IP because they've given you permission. So you can think of license sort of like permission. And sometimes the permission has a term on it. Sometimes it goes forever. Oftentimes with things like business cards, you don't have to renew your Vistaprint license every year. They probably give you what's called a perpetual license to use it. But yeah, that's kind of how you rent out your copyright and your trademark as well. You can rent out your logo or other aspects of your product names all through this document called an IP license agreement. So that's how that aspect kind of works. And that, I think, helpfully covered off what I was going to say about license agreements. And is a nice segue into the last section. So, particularly for businesses who are in the business of producing copyrightable work for their customers or for their clients, maybe you're a web developer or a graphic designer, or maybe you provide business strategy documents for your clients. You might be wondering, well, I'm producing this work for my client. Of course, maybe I want to copy and paste bits of what I did for this client for other clients. So who owns it? But maybe my client doesn't want me to do that. Maybe we haven't talked about this. How's this going to work? And IP can actually be a contentious issue, particularly between service providers and creative service providers in particular, and customers as to who actually owns this and who can use it. So often, and this is something to talk about with lawyers when you are sort of designing your agreements. But often how this works is contracts have a specific type of concept called developed IP as distinct from existing IP. And what you might say is, okay, client, I've got some existing IP. I've got some base templates I use for everyone. That's mine. I'm going to give you a license to use it for your business, but I can also reuse it for other clients because it existed before I ever got to know you. It's sort of my core IP. However, if in our collaboration, we develop some new IP, so I tailor my base templates, maybe it's a website and I make customizations to it. Maybe it's a design and I make some edits to it. Maybe it's a strategy and I customize it to your business. Those developments, that sort of bucket of developments, I'm happy to give you that developed IP. And I won't use that developed bit with anyone else, but the core stuff, the existing IP is mine. So we often slice the copyright in half when we're working with clients in these scenarios. And that's a way of coming to a mutually acceptable outcome where your client gets security that they at least have some ownership over what they paid for, but not so much ownership that you can't go on and continue to run your business. So yeah, that's often how it's managed in those more complex client scenarios. Peter's asked, are translations into other languages of existing original text considered new copyright? That's an excellent question. I think there's a few different copyright issues that arise in the context of translations. I mean, the original work would have copyright in it if it was original. And by using it in a translation, you probably need permission from the original copyright owner because you're sort of incorporating their copyright and taking parts of it, albeit presenting it in a different form. So there's a permission component. But to your specific question, is the translation itself a new work? I think the answer to that question is yes. There's this concept of what's called derivative works in the Copyright Act, where you take an existing work, you adapt it and you modify it. Because there's creativity in this new translation, because there's many different ways to translate a piece of text, many different ways to represent it, many different words you can use to translate the original. I think there's possibly it's in the Copyright Act. I'd have to double check, but there's certainly good case law to suggest that these translations are themselves an original work. And so if someone wants to use a translated version, they would need permission from both the original owner and the person that translated it. So yes, I think the answer to your question is in most cases, yes. But yeah, not something I've dealt with recently. So maybe worth double checking if what I said, if you're going to rely on that particular piece of advice. The second question I think that's important to ask is, so in addition to your own intellectual property, it's common in business for you to use other people's intellectual property. Maybe you're quoting people on your blog, maybe you're reproducing images and those sorts of things. Maybe you're, again, for software businesses, maybe you're using open source software code inside your original software that you're making. It's also important, in addition to making sure you own your assets, to make sure that you actually have the rights to use other people's assets and you're not inadvertently infringing them. So in the case of software, one thing to check is these open source licenses. They appear on the surface to allow you to use their software code and mix it with your own commercial software code and create something novel. And it's all yours, except the open source parts can be used by others. But certain open source licenses, like the GMP license, actually have what's called a viral or infective aspect, where some of these open source licenses say, if you use even a bit of our open source code in your software, your whole software must become open source, and you agree that you will lease your entire software to the world as well. And I do often see software companies using these open source libraries. A lot of the libraries, like the MIT license, don't have this aspect, but I sometimes see them inadvertently, giving up the copyright to their whole core business just by using a bit of open source code, at least technically. So that's one thing to check. Do you have the rights to use software code if you're a software business? If you're not a software business, maybe you're producing a blog or marketing content. Maybe you're using photography or images. Those creators of the original content, the photography or images, it's their artistic work. They've created it, and there's also an other subject matter in there too. The photographer would have the right to the image, as well as the probably the underlying subject matter of the person in the image. So there's copyright to think about in these cases, and that's why these stock websites or royalty-free websites exist. They're libraries where the platform's done the work to get all the permissions for you, and you just pay them a fee to use it, and they give you a license to use it. So I would recommend, to the extent that you're using imagery or pictures off the internet, whether it's for social posts or otherwise, to use these royalty-free platforms. If you choose to just take an image from somewhere, you really technically need to contact the author of that image and get written permission, ideally a written agreement, that you're able to use it for the purposes of your blog or your marketing campaign or whatever it is. But that can be cumbersome, time consuming. You may not hear back from them, et cetera, et cetera. And that's why it's very common to use these sort of more open source royalty free websites for this stuff. You probably see on the internet people not doing what I'm saying, and it is common for people to just copy stuff and share it and post things, and it is the case that they get away with it a lot. The original copyright owners aren't out there enforcing use of their images, but you would be surprised. You do see people that are in the business of putting images online, finding, using Google image search, people that are using it, contacting them, and I've had clients of ours actually, publish blog posts where they've infringed someone's copyright, receive, an invoice essentially for an unauthorized use, and had to pay them out or risk sort of legal liability. So do think about that. If you're using other people's copyright, do you have the rights to use it? So people would have seen this copyright C logo. We talked about the R one for registered trademarks. There's not laws as such around the use of the C as there is around the R, because there's no registration system. If you own the copyright, with your contract that transfers it to you, or because you created it, you can use the C logo. You can't use the C logo if it's not yours. Of course, there's not an easy way for anyone to verify that, but there can be actions against you for misleading conduct if you are claiming that it's your copyright and it's not. But if you're confident it's yours, you can use the C logo. You don't have to use the C logo, but what it does, it acts as a deterrent and stops people copying your stuff. And it's a way to put them on notice that, hey, I know I own this, so you better not copy it. It's my copyright. If someone infringes your copyright, similar to trademarks, you can send them a letter of demand. You can request them to cease using it. You can request compensation. You have legal rights in court. Also, if you just want a quick practical solution, a lot of this, if you see that someone's sharing your stuff on social platforms, you can actually just use the platform's functionality to notify the platform. And a lot of the platforms will take it down if you can provide evidence that it's yours. And that could be a really efficient way to stop people infringing your work. Not legal in a sense, but but certainly a lot of the terms and conditions of these sites, are very much geared towards preventing misuse of copyright. So another way to enforce your copyright ownership. Coming towards the end of the presentation, and I'm just now on to the last slide, just to quickly touch on confidential information. If people do have any other questions they want to drop in, now's a good time as well, and I can try and get to them. But just diving into this last section, confidential information, it's not really IP. Some lawyers, would say you shouldn't really be including this in the IP presentation because technically it's not property. But I think it's important to think of this stuff through the same lens that you think about protecting your copyright and your trademarks. In addition to this stuff that's original and recorded in material form, like your literary works, your code, your design, and so on, and in addition to your brand name, another thing your business has that's intangible, that's important, is your ideas and your strategies. And we said before, there's no copyright in ideas, but that doesn't mean you can't protect these ideas. It doesn't mean you can't protect these things or plans that you have that aren't original enough or whatever to be copyright, or aren't material formed enough to be copyright. And the way we do that is through protecting them as confidential information. So once you've identified what kind of stuff you're thinking about that you think may not be copyright, but maybe it's a plan for your business to do a partnership or merge and expand somewhere, or maybe a plan for you to make changes to your structure, or maybe a new product idea that you don't want your competitors to know about. The way you can protect these is through contracts. And so most people will be familiar with this document called an NDA, a non-disclosure agreement. It's a very common form of a very common tool that people use to protect their confidential information. And it's a simple document. In most cases, it says, I'm going to share some information with you. By signing this document, you agree that you won't tell anyone. You'll keep it a secret, unless maybe you're required by law or a court to tell them. You'll keep it a secret. And if you don't keep it a secret, I will be able to sue you for sort of breach of your non-disclosure agreement. So NDAs, we often recommend most businesses have one in their pocket, just a simple one-page NDA that they can use for business meetings, and just say, look, can you sign this NDA before I share stuff with you? And that can be a powerful deterrent for people to treat the information you're sharing confidentially. You can share it with employees. Most employment agreements and contractor agreements will have a clause that is basically an NDA clause, so you don't need a separate NDA for them. But even the act of getting someone to sign a second NDA can help employees and contractors keep things particularly secret. If you're a startup and you have a pitch deck, you may want to get an NDA signed before you give investors access to all your financials and strategy documents. Basically, it's a good tool to protect this information that may not be copyright, but is still very important to your business. And as I mentioned, you have these rights to sort of enforce them. So that is all of the content. I've noticed a couple of questions. I'll answer them in a moment. Just in case people drop off, a quick reminder, if you join late, if you do need help with any intellectual property stuff, particularly maybe trademark registrations or help with your brand protection, or maybe you need some contracts drafted, we have this Black Friday offer available until the end of November. So only a week now, and it's just to get this kicked off before the 30th of November, not to get it all done. So do contact our team and let them know you're at this webinar, and we'd love to help. I'll just quickly deal with a few questions now that we have in the chat. Tara has made a comment: trade secrets can restrict director, employees, consultants, contractors. I think that's maybe a statement question. Trade secrets are kind of an American term more than an Australian term, but they do refer to confidential information. They're sort of synonymous. And yes, indeed, they can be used as a way of restricting those actors in your business from stealing information about the business and using them for competitive businesses. Sophie's asked, I'm hoping to trademark my mobile app called Dome, but in full is titled Dome Home of Fans. Because Dome is such a common word, is it worth trademarking? And will I have more success if it's a full title? Good questions. That's probably a question actually that's worthy of an IP consult with a lawyer. Just because dome's a common word doesn't mean you can't trademark it. Apple is a very common word, but Apple were able to trademark it because they trademarked it in the computer class. And so dome may not be a common word in technology as much as it's just a common word generally. So it may be that it's, I'm not sure, we probably need to look at the laws and the registers, but it may be that dome is unique enough. If it isn't, yes, it's common to do the longer title. You get less broad protection if it's a longer title, but still it can fulfill some of the purpose. So it's a very good and sort of classic question that we help out with as part of our IP services. So I'd encourage you to book a call and chat about that, and you can work out the best strategy and then try for a trademark application if that's the agreed approach. Anonymous has asked, could trade secrets be declared and added as a meeting minute or document for internal parties? Look, yes, you can make a note in a meeting. So yeah, the laws around confidential information actually don't require an NDA. If someone is told in writing that something is confidential, then you can still potentially have a claim for what's called breach of confidence. So documenting secrets or things that have come up as confidential and making it clear that everyone was informed of that in the meeting can be good evidence for the fact that something is confidential. It's still much better to get an NDA signed by people before this information or secret information is shared. But it never hurts to be even clear about it. If people have signed these agreements, there is value to documenting it as well. I might just jump to Lance's questions and come back to Rhonda because it looks like it's on a similar point. If you mark a document as confidential, but the person, say a contractor, has not signed an NDA, is there any sort of confidence? Yeah, so yeah, I think I sort of just answered that one. But yes, there is. There's an action for what's called breach of confidence, and if someone knows the information was confidential but leaks it. If you've marked it as confidential, it's better than nothing. You'd have to make a claim that they knew it was confidential. It's not as black and white as an NDA, so it's worse than an NDA, definitely, but it's not nothing. It adds something. So there is some protection, but it's just not super strong. And Rhonda mentioned, yeah, you're at the end of your opposition process and are writing a written submission. Can we help with that? Potentially, yes, we can. Do feel free to reach out to our team. And we have, some trademark lawyers that do that kind of work, so we can potentially give you a quote for it. Awesome. Well, thank you so much, everyone, for attending. We are trying to do these monthly on various topics. Would love feedback. If there's any other topics you want to see, do feel free to also shout out. And I enjoyed the session, so thank you so much for attending. We'll see you later.